Picture this. You are sworn in as a juror. The evidence looks tight. The law is clear. On paper, the verdict should be easy, but in your gut, it feels wrong. The way the law hits this person in this moment does not look like justice. You vote not guilty anyway. That move has a name: jury nullification. It is one of the oldest, most controversial powers in American criminal law. Courts do not advertise it. Judges tell jurors to follow the law as instructed. Lawyers are warned not to argue for it outright, yet the power sits inside every jury box. And in the case of Luigi Mangione, a lot of people are asking whether that quiet power could decide the outcome. Here are the basics. Prosecutors say Mangione tracked and shot Brian Thompson, the CEO of United Healthcare, on a Midtown Manhattan street in December 2024. Mangione was arrested after a multi-day manhunt and now faces state and federal charges. The federal case seeks the death penalty. He has pleaded not guilty. His lawyers say he will fight the charges. Online, the case exploded. Debates about the health insurance industry, memes, fundraisers, and heated takes about whether anger at a system can ever excuse violence. The courtroom will not be Twitter, and it will not be Reddit. The jury will hear witnesses, view footage, study timelines, and weigh intent. They will be instructed to apply the law to the facts. Still, jurors are humans. They bring life experience, bias, and conscience into deliberations. That is where nullification sometimes slips in, through the gap between what the law demands and what people believe is fair. Here is the history in short. Colonial juries refused to convict printers for seditious libel. Northern juries balked at the Fugitive Slave Act. During Prohibition, many juries shrugged at alcohol laws. In some Vietnam War protest cases, juries delivered acquittals despite clear violations. And the dark side, nullification also let white defendants walk in racist killings in the Jim Crow era. The tool can cut for justice or slice it to pieces. That is why judges fear it and why law professors argue about whether it is a democratic safety valve or a threat to the rule of law. So what exactly is it? Here's how it works. A jury believes the defendant violated the statute but still votes not guilty because they think the law is unjust or its application would be unjust. A not guilty verdict ends the case. The government cannot appeal. Jurors cannot be punished for their verdict. Courts try to prevent it by giving strict instructions and blocking lawyers from inviting it. But once the door closes on deliberations, the jury's power is real. How would that intersect with the Mangione trial? Start with the narrative pressure. Many Americans distrust the health insurance system. They have personal stories of denials and delays. Thompson, as the head of a giant insurer, symbolizes that system to some people. If jurors view Mangione through the lens of protest or desperation, sympathy can grow. Sympathy alone does not equal nullification, but it can soften the edges of strict law. Next, consider the evidence fight. Prosecutors will try to lock in premeditation, surveillance, planning, motive, and a clean chain of custody. They will work hard to keep the story about a targeted killing. The defense will attack gaps, timing, ID, mental state, and alternative inferences. They will humanize Mangione and push the idea that real life is messier than the charging papers. They cannot stand up and say, ignore the law. But they can tell a story about moral context and ask jurors to hold the state to every element beyond a reasonable doubt. In a close case, conscience can tip the scale. Jury selection will be a battleground. Prosecutors will strike anyone who looks like a movement juror, people with strong anti-corporate posts, insurance horror stories, or activism that hints at protest-style sympathy. The defense will look for independent thinkers, skeptics of mandatory minimums, and people who value conscience and mercy. Each side will probe whether a juror can follow the judge's instructions even if they disagree with them. Everyone knows the script. Nobody will say the quiet part out loud. The judge's instructions will matter. Expect language like, "You must apply the law as I explain it. Set aside your feelings. Decide only on the evidence." Expect warnings about sympathy and passion. Expect a sharp line drawn around what is relevant and what is not. The defense will try to fit moral context inside admissible boxes, state of mind, motive, mitigation, while avoiding a contempt warning. The prosecution will run to the line every time the defense strays, objecting to keep moral drama out of the record. There is also the risk of backfire. Jurors who feel manipulated by emotional appeals can harden. If they think the defense is hinting at a free pass, they may double down on the letter of the law. And remember the dark history. Nullification can excuse cruelty as easily as it shields protest. A prudent defense lawyer treats it like fire, useful only from a safe distance. Recent pretrial skirmishes underline how charged this case is. There have been fights over which court goes first, disputes over discovery, and even controversy about accidental disclosure of Mangione's health information. Each side accuses the other of overreach. Those headlines make noise outside the courthouse, but inside, the jurors will be told to ignore it. Whether they can is another question. What would a nullification-flavored defense look like without saying the word? It leans into three themes. First, dignity. Show the human being, not the headline. Family, work, letters, the full picture. Second, nuance. Stress how many steps had to align for the incident to happen and how many alternative readings exist. Third, scale. Remind the jury that criminal law is a sledgehammer and this case may demand a scalpel. The message is not, let him go because you hate insurers. The message is, if the law's fit is loose, the benefit of the doubt belongs to the accused. Prosecutors will counter with structure. They will say the law protects everyone equally, that corporate dislike is not a defense to murder, that vigilante logic turns cities into war zones, that the jury's role is to find facts, not rewrite policy. They will anchor their case in elements, intent, act, causation, identity. They will warn that bending rules for one defendant invites chaos in the next case. The public angle matters too. Trials are not only legal events, they are civic rituals. When a verdict lands, it sends a message about what conduct we punish and what we tolerate. An acquittal here, whether from doubt or nullification, would be read as a statement about power, healthcare, and frustration. A conviction would be read as a statement about order, procedure, and the line between protest and violence. Either way, the jury will write a page of social history by checking a single box on a verdict form. So what should jurors actually do? Follow the instructions. Test the state's proof. Examine each element. Talk it out. Pressure test your own bias. Ask the hard questions in that jury room. Do the facts support the charge beyond a reasonable doubt? Does the law, as written and explained, fit these facts? If the answers are yes, the law says convict. If not, the law says acquit. And if a juror believes the law forces an unjust result in this rare case, the system trusts the conscience of 12 ordinary people, however uneasy that makes the lawyers. One more reality check. Nullification is rare. Most juries follow the instructions to the letter. Judges work hard to keep the focus on the evidence. Appeals courts reinforce that structure. The Mangione case will likely rise or fall on proof, not philosophy. But the philosophy is not going away. It lives wherever ordinary people sit in judgment over hard facts, hard laws, and high stakes. For lawyers and citizens, the takeaway is simple. If you want a legal system that feels fair, do the boring work. Better statutes, clearer jury instructions, honest charging decisions, and cleaner discovery. Trials should not depend on jurors quietly rebelling. They should depend on the state meeting its burden and the defense getting a fair fight. When that happens, conscience serves as a compass, not a grenade. However this case ends, it will teach. If there is a conviction, expect appeals, sentencing fights, and long debates about deterrence. If there is an acquittal, expect national arguments about what juries are allowed to do and what they should do. Law schools will spin up lectures. Legislators will draft proposals that cannot change the basic fact that juries answer to the law and sometimes to their own sense of justice. This story started with a brutal act on a city street in a country already split on who deserves mercy. It now sits in the hands of people who did not ask for power but have it anyway. 12 chairs, one verdict, and a quiet question that has shadowed American trials for centuries. When the law and justice pull in different directions, which way do you lean? There is also the hung jury path that sits between strict application and open nullification. If even one juror refuses to vote guilty, the result is a mistrial. The state can try again. Sometimes that single holdout is driven by doubt, sometimes by conscience. You will not see a headline that says nullification if a jury hangs, but the effect can look similar. No conviction, new leverage for the defense, and time for narratives to cool or harden. Pretrial publicity will hover over this case. Courts can question jurors about what they have seen and whether they can set it aside. They can even sequester a jury, though that is rare. Phones live in pockets, and opinions ride in with them. Lawyers who face that honestly by addressing bias without shaming jurors usually do better. People follow rules more readily when they feel respected. Sentencing anxiety is another force. Jurors are told not to consider punishment when deciding guilt. In practice, some do. The possibility of a death sentence can weigh on minds, even if the judge says it should not. Defense lawyers will emphasize humanity, remorse, and the complexity of intent. Prosecutors will stress that any penalty phase comes later, under different rules. Inside the room, those lines blur. Finally, watch for compromise verdicts. In multi-count indictments, juries sometimes acquit on the top charge and convict on lesser counts. That is not nullification. It is a recognition that proof of a lesser mental state or different element may be stronger. Expect both sides to fight over which lesser charges the judge includes in the instructions. Those choices can shape the path to consensus or to gridlock. Pull back and look at the institution. Jury trials are messy on purpose. They reflect community judgment, not just technical logic. Nullification is not a policy. It is a symptom. It flares when people believe written law cannot carry moral weight in a particular case. Whether that feeling is wise or reckless depends on the facts and the moment. The Mangione case will test where that feeling sits in 2025. Thanks for joining us today at Due Process Daily. Throw us a like and consider subscribing to the channel to help us grow.